sent like information, so everybody's Googled you. Everybody has doubts about policy work and working in financial regulation. They're all already smiling because they want to catch you after class.
No, absolutely. So happy to answer all the questions.
So essentially, like, I'll keep it brief. What are the...
Yeah, it's here actually. That's it.
No,
yeah, so, no, seriously.
Just 30 seconds. Let me finish. Don't be so modest. One of the key drafters of the Insolvency Bankruptcy Code as we see it. Part of a lot of research, debate, all the committees that you see, all the talk that you have, he's been a part of it. Corporate experience also has like that beautiful Harvard tag, which all of you want sometime in life. So that also exists if you want to like chew his head off because he's come all the way here. And with that, anything related to financial regulation in India when it comes to like MCA work, any development, any amendments, law, regulation, frameworks, Vidhi has been involved with him at the spearhead of it. So I'm just going to leave it at that and let him take you through the IBC principles.
Thanks so much, Shoshana. My name is Devon Shu. I lead the corporate law and financial regulation practice at Vidhi. Am I audible? We've been involved in the conceptualization and drafting of the bankruptcy code, and we have been working with the government for the last 4.5-5 years on this reform, and we continue to work with them. This presentation is structured as kind of a backgrounder to the enactment of this law, and basically to tell you about what are some of the key design principles which went into the drafting and how the law has kind of evolved over the last 2.5-3 years since it's been implemented. And I'm happy to answer any questions that you might have as we move along. So just to before we get into the substantive stuff, let's basic details about the process. So the Bankruptcy Law Reform Committee was set up in August 2014. They issued their first report in Feb 2015. So it was basically split into two parts, an interim report and a final report. The interim report was intended to suggest immediate reforms, and the final report was looking at a large-scale IBC. And just a political economy point, nobody at that point thought that an IBC-like law could have been enacted so fast. So therefore, they had structured it in this manner. But as luck would have it, we did manage to have the law in 2 years. After the final report was issued in 2015, it got tabled in the Parliament very soon. Then it was referred to a joint committee. It finally got passed by the Rajya Sabha on May 11, 2016, and got enacted the same month. So soon after that, the government set up 4 working groups. They set up a regulator. The regulator was entrusted with the responsibility of drafting regulations for implementation of the code. They worked under very tight timelines and were able to notify most of the regulations by end of the year, which is December 2016. And the first IBC application was actually filed in January 2017. So, and as luck would have it, we were involved right from the conceptualization stage right up to the notification stage. Now, you guys have probably already studied this, but just to give you a brief background. So before IBC, basically the bankruptcy framework was fragmented. It was spread across the Companies Act, the Sikh Industrial Companies Act, SAVESI Act, which was basically an act for recovery of debt, and the RDDB-BFI Act, which is for another act for banks to recover their debt through DRTs. Then RBI had its own debt restructuring schemes. Some of them are still in place. And then finally, we had 2 personal insolvency acts for personal bankruptcy issues. So one of the key objectives of the law was harmonization of this fragmented framework. And I'll explain how that happened as we go along. The second most important objective was to develop a market-driven process, because the previous bankruptcy regime was very government-driven or court-driven. It was not a market-driven process at all. And since some of us who were involved in this drafting were coming from a M&A market type of a background, we realized that there is a lot of value in making this a market-driven process. And as we see, the way the law has kind of evolved over the years, it's essentially the market which has been the key driving force for its smooth implementation. The law is largely based on international best practices. There are some very unique features which no other jurisdiction has. I'll talk about that when we reach there. A key objective was to improve India's ranking in the World Bank's Ease of Doing Business framework. As you know, India is currently ranked at about 100 odd. It was ranked about 137 or 40 before the IBC came in for the resolving insolvency piece. The NPA crisis, as some of you might know, was a huge problem. So 2013, 2014, when Dr. Raghuram Rajan came in as the RBI governor, this was high on his agenda. In fact, he was one of the key driving forces for this reform to actually have been initiated at that point. So, so that was obviously on, high on the government's agenda as they were conceptualizing this reform. And lastly, we have a very, bank-driven credit market. We don't have other alternative sources of debt finance. Like we have them, but the market is not as evolved. Like we don't have a very well-developed bond market, and our banking industry is kind of, heavy on secured credit. So one of the key objectives of the IBC was to develop alternative sources of finance in India, and some of that informed the design of the code. We'll see that as we go ahead, and I'll talk about some of those salient features. Now I'll introduce you to the new law by comparing it with what the old law was. That'll kind of give you the context as to how some of the design features are drafted the way they are drafted. Now, under the Sikh Industrial Companies Act, which is basically the law before the IBC, one could file a petition for resolution after the entire net worth of the company had eroded. So it was known as a test of erosion of net worth. So basically, essentially, by the time you take the patient to the hospital, he's very close to his death. Essentially, that's the upshot of that kind of an approach, and that is why in IBC the trigger event is just a single default, so that very early on you're able to initiate the proceedings, and so that's so that's one of the key design features which was informed by the mistakes of the past, which had to be corrected. Now, secondly, the Sikh Industrial Companies Act applied only to industrial companies, right? It didn't apply. So it didn't apply to a company like Kingfisher, which was facing bankruptcy issues, but could not seek any kind of bankruptcy protection because SICA did not apply to it. Whereas IBC applies to all kinds of companies other than financial service providers. So this is again another key feature of IBC, which makes it very different from Sikh Industrial Companies Act. Another big problem with the Sikh Industrial Companies Act was that it allowed the old management to remain in the saddle while the restructuring or the resolution was being attempted. So just to give you an example, once a case was filed, there would be a moratorium in place. Nobody would be able to recover their assets, but the promoters and the managers continued to run the show, which obviously gave them opportunities to siphon off assets and made life difficult for creditors. So therefore, in the IBC, the moment a case is filed and it gets admitted, the management gets displaced by an insolvency professional. So this is again informed by the problems one faced in the past. And this is a radical change in the Indian context, given the political economy. Most of our companies are promoter driven. They're all very well connected politically. So this was a huge change. And a lot of people actually thought that this will not go through the parliament. But I won't go into details, but the fact that Kingfisher became bankrupt, and you had that entire mobilization of shame against the promoter around the same time as the IBC was being drafted. My sense is that that kind of really helped the process, because personally speaking, I thought that this provision will definitely get diluted once it reaches the parliament, but it just went through as is. And my understanding is it's largely because of the Kingfisher crisis, and I think nobody had the courage at that point to oppose a law like this, given that crisis was unfolding at that time. SICA actually put a lot of undue emphasis on rehabilitation. Like, even if a venture was not viable, instead of biting the bullet, one would just attempt to try and restructure it and try and resolve it, no matter what, even if it's an unviable business. Whereas in the IBC, it's a very, very market-driven, creditor-driven process. And if a company is not viable, you have to bite the bullet. You have to, send it for liquidation, and the creditors have that flexibility. Again, there is a big political economy angle to this. And now, SICA was enacted in 1985. The nature of the economy was very different. Trade unions are very powerful. It's no longer the case today. Trade unions are definitely powerful, but not as powerful as they used to be at that time. And with the growth of private sector, although our employment laws are still quite outdated, the way our market has evolved, once a company enters bankruptcy, employees are invariably able to find jobs at other places. Like, just to give an example, a lot of people who lost their jobs after the jet bankruptcy were absorbed into other airlines very fast. That just didn't happen in the past. So therefore, the state actually had to step in, and therefore probably you could understand how they had a rehabilitation bias, which possibly is no longer required in today's day and age. So that's on the market-driven approach of IBC and how we don't have a rehabilitation bias. Lastly, this is one of the most unique features of the law. SICA did not have like any tight timelines. Okay, so one could take forever to resolve an entity. But one of the most unique features of IBC is this timeline, right? This deadline. If you don't resolve within 180 days, which is extendable by another 90 days, the company can go into liquidation. So I call it the guillotine. It's like, if you don't finish within a particular period of time, you will eventually get into liquidation automatically. So this is this kind of, no other jurisdiction has a provision of this nature. So therefore, this makes IBC really unique. And people say that most of our laws are copy paste from other jurisdictions. So this piece is like one feature of the law which no other jurisdiction has, which is an automatic liquidation order if there is no resolution within a certain period of time. Lastly, as I said, historically we've not had alternative sources of finance in India. That's largely because laws like SARFACI, etc., SICA, etc., we are designed to favor the bank creditors, but IBC treats all financial creditors alike to a large extent. So therefore, the idea is that this will encourage other forms of financing in India, and it's already, we are seeing that there is already a growth in the bond market after the enactment of the IBC. So clearly, it is working as intended. Now, just to compare the IBC with the erstwhile Companies Act, because SICA was our only reorganization law, but Companies Act also had a winding up framework. I'm sure some of you already know about it, and insolvency was recognized as a ground for winding up. But once a winding up order was made, it actually took a lot of time to get a winding up order from the court. It took years to even get a case admitted. That's largely because inability to pay debt was very broadly and vaguely defined. It was very difficult to establish it in practice. So obviously IBC addresses that. And once an order was made, the liquidation process was actually implemented by an official liquidator. It's like a full a governmental setup, very, very bureaucratic, so which was besieged by delays all the time. So therefore, as discussed with the court, it's an IP who runs the show. There is no direct entry into liquidation under the IBC, right? So whereas under the Companies Act, one could directly file a case for winding up, that's just not possible under IBC. You have to necessarily go through the resolution process, and only if that fails or if the creditors decide to take you into liquidation, will you be in liquidation. Courts had a very, very big role in the entire liquidation process, whereas in the IBC, the role of the NCLT is fairly limited, both during the resolution process and the liquidation process. Now that's basically a kind of a comparative framework from where we were in the past and how the past experience kind of informed some of the design principles of the IBC. Now we'll talk about some of the key features of the code. I understand that you've probably already read some of this, but I'll kind of just take you through that again and give you some reasons for why it was drafted the way it was drafted. Yeah.
So we've been debating the default versus non-default mechanism. So maybe if you could just tell them what the process of default versus non-default is in this whole.
Understood. So as I said right at the outset, for the test for getting a case into the bankruptcy system under the Sikh Industrial Companies Act was erosion of net worth, and which was basically way after default. Like default was like 2 years back. Erosion of net worth is like your entire capital is wiped off. Like so, basically, you've gone beyond redemption. So that was under Sikh Industrial Companies Act, and then under the Companies Act, you had this test of inability to pay debt, which was broken down into 3 different kinds of tests. You had this test of commercial insolvency, where you had to actually see whether the company had become insolvent on balance sheet terms or not. Then you had the statutory notice-based test, where somebody had to serve a notice, and you had 30 days, and if you didn't respond, then you would be deemed to be insolvent. But the point being that the test under both SICA and the Companies Act took a lot of time, and it was virtually impossible to get a case admitted, and therefore the BLRC thought that it has to be a very, very objective test, and therefore they decided on default. And you would have probably tracked it. In most of the cases that happen under the IBC, there is very little dispute, especially for financial creditors. There's very little dispute on cases filed by financial creditors. Operational creditors is a different story, but for financial creditors, there's very little, because you had well-documented loan documents. Money was due on one day, it didn't come, there's a default. So there's very little scope for argument and delays there. So therefore, that's how kind of that default-based test works. Now, for financial creditors, there is no distinction between secured and unsecured, as I said, whether you're a bondholder, a bank, pretty much everybody is treated the same at the admission stage. For operational creditors, there's a slightly different process, as you probably know about. They have to first serve a notice, and if there is no payment and there is no dispute, then a case can get admitted. And corporate debtors, they are allowed to file only after a default takes place. There was some discussion in the committee on whether the debtor itself should be allowed to file even before default, because they are in the best position to know if something is going wrong. And but eventually a call was taken that in the interest of certainty, let's make it default, because you never know how they might game this, because there will be a moratorium. So therefore, they might get a moratorium before, but I think this is one provision from an academic perspective that needs to be explored a bit more to understand whether we should allow debtors to file before, because even default for a lot of people is way late in the process. Because in some of the other jurisdictions, like in the US, Chapter 11 petitions can be filed even before default, right? So ideally, the earlier you file, the better chances you have for rescuing the company effectively. So I think this is an interesting academic question that one should explore to see whether this this test of default works for corporate debtor itself. It's a very objective test. NCLT doesn't have to apply its mind beyond a point. And if the case is admitted, then the insolvency process commences. And once that happens, there is a moratorium that nobody can file cases. There are some exceptions to the moratorium, but broadly, essentially, it's a calm period, which is basically a facilitative period for all the creditors to come together and find a solution. We've already talked about displacement of management. An IP steps in, the management get displaced. In practice, what happens is that everybody is there. Actually, it's not that people are thrown out, just that their powers become subject to the IP's final word. So therefore, just to give you an example, if it's a big steel company, an IP will step in. Not that everybody gets thrown out; they're still there. But whatever decisions they take, they have to run it through the IP, especially in the initial stage. And one important point to note here is that the IP's responsibility is to maintain status quo, right? So he's not there to kind of disrupt or basically stop activity. So therefore, so when we say displacement, it's a very strong word, but in practice, basically he just steps in and ensures that everything stays as is. Yeah, so he's interested with running the business as a going concern, which means that to maintain status quo. Now, one of the key features of the moratorium is that certain essential service providers are required to continue supplying their services. And currently, these services are electricity, water, IT services. Like basic survival services can't be terminated during the process. And the idea is that if those services stop, then basically you'll have nothing to restructure. And this is actually taken from UK law. And interestingly, under UK law, they had a very different objective for having this provision. It was health related. Like it's a huge factory, you at least want water supply, electricity to continue while you're trying to resolve. So it was a very different policy objective. And we've taken that, but we didn't kind of get into the policy objective at that time. We were just like, this might be useful, but we realized later that the objective was health. And because there is some flexibility with the regulator to add more services to this list. So it's possible that in the future you might see even regular supplies to become essential. And then, but I think this will have to be structured industry-wise. Like for instance, in the steel industry, oxygen is a very critical raw material. So maybe you might want to make sure that to be able to successfully resolve a steel manufacturer, you make oxygen an essential service, and so that service continues. But at the same time, you have to give some protections to these guys, because it shouldn't be the case that they are forced to supply and they don't get paid. So the law then says that folks who are forced to supply should be paid before everybody else as part of the resolution costs. A very important power that the IP has at the initial stage is the power to raise interim finance, which is basically, on day one, if there is a liquidity crisis, this guy can actually raise money from the market, and this money will have priority over all other credit. So this is called interim finance or rescue finance in other jurisdictions. And the idea is that, at this stage, if you don't give super priority to such finance, nobody would be interested in throwing good money after a company which is going down. So therefore, by giving them super priority, you're kind of incentivizing some people. And typically, the rate of interest for such financing is significantly higher, because it's a risky company that you're giving money to. But in practice, such financing does actually happen. Yeah.
Sir, I have a question.
Sure.
So, sir, you said that one of the policy objectives of the law was that they wanted to give ground to the creditors, all kinds of creditors in.
Sorry, can you say that again?
So they wanted to give more kind of room to creditors
Correct.
to decide how to make this work. So, what was the need of making any kind of distinction between financial and operational creditors, especially because when you also said that during moratorium, the bare minimum resources required by the insolvent industry should be supplied during that time, and in most cases that would be operational creditors. Even in JGLS, that was the case. So why do they have very limited role compared to management?
No, excellent question. So the background was that in the past, I should have probably mentioned that when we were discussing the old laws, like under the Sikh Industrial Companies Act, the operational creditors actually did not contribute effectively to the resolution process, and in practice, they were never prepared to take a haircut. Haircut means that the restructured debt. So they were like, this is what is owed to me. I need to be paid the entire amount. Otherwise, I won't, cooperate with you, and nothing will be resolved. And given the kind of industries that we have in India, if you were to allow all operational creditors to have a say in the process, you would have like 10 banks and 10,000 operational creditors. Now, how do you kind of deal with that in bankruptcy? Other jurisdictions also have to face this situation, and they do deal with that. So they create separate classes of committees to do that. But so the solution that we proposed was an extreme solution. We like keep them out, but give them limited protections. I'll come to that piece later. But that was your question is actually linked to the composition of the committee of creditors and why they have a lesser say. But so that's the background. Basically, it's impossible to resolve a company with 10,000 operational creditors and 10 banks and other financial creditors all sitting together in the same room. And this is a big problem in bankruptcies elsewhere. So we've kind of got around it. This was challenged in the Supreme Court. Supreme Court upheld the constitutional validity, saying that this is justified. And we've actually explained the rationale in the notes on clauses. I don't know whether it's part of your course curriculum. You should take a look at the notes on clauses. We actually explained why this distinction was made. Yeah?
Sorry, my doubt was a few slides back, but I wasn't sure if you were certain.
No, sure.
In the slide where we were making a distinction between rehabilitation-oriented approach of CICA as compared to the creditors-oriented approach in IBC, one thing which a very fundamental understanding issue which I had was that a creditor would always have a negative sort of a POV to the situation if a company is distressed. Be it economically or financially distressed, that is a different question altogether. But say if a company at a particular point of time is financially distressed and for that period is not able to clear off its debt, but say if its assets are kept together, it can still function. But a creditor's approach will always be to siphon its money, to get its money back. So wouldn't this approach, this new approach, might be a hindrance?
No, so you're right. A creditor is only worried about his recovery. Okay, so he wants his money back. He wants to satisfy shareholders. But the moratorium actually prevents that during the IRP process. And it's one of the, therefore, before, I didn't talk about SARFAESI, but before IBC, between CICA and IBC, you had SARFAESI Act, which allowed creditors to recover their dues. And all they did was, the moment there was a default, they would just file these SARFAESI actions and take the asset out. So, and what would happen is that once the good asset is out, there is nothing left to restructure. So, but they also realize, over a period of time, that this is not in the best interest of, value maximization. Because, it's not easy to just take an asset out and try to sell it. Because there's a possibility of multiple appeals even on the recovery action. So IBC actually gives them a very clean solution. It's like, everybody has to come together. Okay, there is a stay for 180 days which can go on, but whatever happens at the end of it is a clean solution. And they're kind of realizing it over a period of time that this is actually a better solution to piecemeal recovery, which is value destructive. But conceptually, I agree with you that in fact for a lot of creditors, it will be like, for instance, if I have like 3x cover, which is like if it's a 100 rupee loan and I have a 300 rupee security, it's cheaper for me to just get my security in force and recover my money and get out. Why should I wait for an entire year to get that money? But in the Indian context, even getting that 100 rupee outside, regular IBC has been very difficult. Even SARFAESI in theory is fantastic, but in practice it's been litigated so much that it's difficult to even get your 100 rupee back, despite the fact that you're fully covered. She's practiced as a financing lawyer, so probably she's a better person to answer that.
So very interestingly, though, I've been harrowing them with negotiation exercises on how will they resolve a debt case. So that's how our
Understood.
entire session on law started. So do you guys remember this bit where we were talking? We had now that you know these concepts, now you know who the financial creditor was in the case that we did, and you know who the operational creditor was. Corporate guarantors were the operational creditors. Yeah. So in that, do you now listening to what the law has instructed? Do you think the 180 times paid for like the operational creditors, assuming in our case there was only one corporate guarantor, imagine there were 20. You really think that you could come up with like a restructured resolution plan? Will the lenders let go of money? Someone Shark Tank, yeah? You just break apart the company, no? And then you just whatever you can recover, you take it and go, right? Correct. So do you, and now you understand like why the entire the conversation on what is the debt and what is the creditor who is the creditor who has the right first becomes a requisite, a prerequisite in understanding the different structures at the resolution plan stage. You guys get it? Now you get the distinction.
Okay, so we've talked about interim finance or rescue finance. Then IP also has the flexibility to create new security interest over the company for getting new money with the consent of the COC, even before a plan is approved. And once one big power that the IP has, or a responsibility that he has, is to go after preferential transactions and undervalued transactions. So preferential transactions are essentially, so you have this vulnerable period in the lead up to bankruptcy where, a lot of, if you have siphoned off the money to some other creditor or some other related party, etc. So it's the IP's responsibility to go after those transactions and get that money back. It's a separate area altogether. Probably you guys will study it as part of your course. And you also have, these provisions on undervalued transactions where, for instance, if a property is for 100 rupees, you give it to someone for 10 rupees and essentially you extract the value there later. Basically, all these transactions are supposed to be cancelled and you need to get the money back, and that's IP's responsibility. Unfortunately, we haven't seen much action on this because, all of this has to happen within the, limited 180 270 day period, and it's so fast paced that the IPs just have not had the time to have these separate petitions to get this money back. This is an evolving thing, I think, especially some of these big four type of IPs, they do have the bandwidth, they do have the resources to do this. But the challenge is that here you are kind of essentially throwing good money after bad, because ultimately, the NCLT will decide whether there was a preferential transaction, whether there was an undervalued transaction. So would somebody want to take that risk? Yeah.
There was a point that the IP had to create security interest. So it's a very valid point that IP should be allowed. But would the committee of creditors agree to that? Because it will, extinguish their interest, not extinguish, but there will be more interest in the asset that the company has.
So that's why it's linked to their approval, and it's basically tied to the interim finance piece, because if there is somebody who's willing to give money and he puts a condition that, and none of the creditors want to put in more money, he says that I'm happy to give, you need to give me some security and you need to give me this interest rate. So therefore this is just an enabling provision, and if the COC doesn't agree, then nothing happens. But you're right, conceptually, there is a risk that, it's a super priority over their security. So therefore, they'll be worried if something bad were to happen, I'll not get anything. But these kind of provisions, are there as enabling provisions for the COC to decide. So I'm not entirely sure in practice whether, once you have some practitioners here, maybe they'll be able to give you a better answer whether this is actually being utilized in practice. But from our perspective, this was an enabling provision, and given the fact that this requires a COC approval, there is no risk because they have to decide. This is the fact that COC is driven by financial creditors. For those of you who I'm sure you followed that question that gentleman asked there on why it was just financial creditors, but just to repeat it again, just to make sure that it's an efficient process, and typically OCs are actually not in a position to take commercial calls, and they're not in a position to take haircuts. So therefore, you let financial creditors who are in a better position to take these calls, and that's why the committee of creditors only has financial creditors. So therefore, you would have probably, those of you who are tracking the home buyer litigation, I don't know if you know about it. The IBC was amended to recognize home buyers as a class of financial creditors. I think it was a largely political type of a move. Supreme Court has now said that they are conceptually financial creditors. I don't agree with that because there are so many such transactions where which are essentially in the nature of a customer and a service provider or a manufacturer, and if you were to call this kind of a transaction a pure financial transaction, that there would many other such transactions which will also get covered. So I don't know how this will actually play out, but for now, home buyers are recognized as financial creditors, and they have all the rights that financial creditors typically have, and in a lot of these home buyers cases, you have thousands of home buyers who have to come together and decide, and it's been a big problem. So basically, the same problem that one would have faced if we had OCs in the committee of creditors. So now the government had to propose an amendment to reduce the threshold for approving a plan and make it present in voting for home buyers. So that because a lot of these home buyers are not turning up for these meetings in time, and no decision could be taken because the requirement was that the plan has to be approved by 66% of creditors by value, and it didn't say present and voting. So you had to ensure that you get those numbers. It was just not happening. So now they've created an exception for home buyers to say that whoever is present, 51% of that, and then the relevant percentage of that, and you're through. Sorry, you had a question? Okay.
I'm just going to tie this back to our class on the REITs transaction that we did. Do you remember the real estate investment case that we did? So imagine a situation where you have 200 of such investors, because obviously the corpus to invest in something like a DLF would be very high. You saw the numbers that we were playing with. Imagine that situation where each association member has to come up and say, I'm a financial creditor because I paid 7 crores as flat money. Can you imagine the IBC litigation that would ensue there? Yeah.
No, but the reality is now these guys are recognized as financial creditors today, and we've seen a lot of litigation over the last 2 years. And with this amendment, maybe it will reduce, but I don't think it will be completely wiped out. I'm sure you'll see a lot of litigation on this, especially this home buyer, because the reality is that logic of people being able to take commercial calls doesn't apply to them. They would want their homes. So therefore, what resolution are we talking about? Resolution is about making compromises, cutting losses. With home buyers, I think everybody who was given money would either want the entire thing back or want their homes. I think there is no midway. And I'm not sure how will bankruptcy kind of solve their problems. So let's see what happens there.
Just a continuation to this. I didn't go through the case, but didn't Supreme Court contemplate upon not making them financial creditors, but say make a creditor category which gives them enough powers, but still does not include them in the COC per se, say operational creditors or something on those lines? Because again, financial creditors, as you said, need to have a certain level
Correct.
of intellect for them to make a wholesome and a good resolution plan per se, which home buyers like us, a layman person, wouldn't have.
So they just basically went by a conceptual definition that they are providing credit for building the homes, because the money is not coming from banks, but the money is coming from them, and therefore they are creditors, which to my mind doesn't make sense. So you can write a critique. I'm sure if conceptually, if you look at it financially, let's look at any jurisdiction which recognizes such kind of a home buyer as a financial creditor.
But sir, in actual practice, all these buildings and the projects that continue is because of these money, flat purchase of money. So as and when you get the OC, as and when you give the possession, you get more money. Otherwise, the banks are not going to provide them with these.
Understood, but wouldn't that logic apply to a lot of other businesses also? Like for instance, if you're manufacturing something, right, and you're manufacturing on the basis of raw materials. isn't that also credit? Like, I can't manufacture anything without that raw material. So does it mean that that guy also becomes a financial creditor? Like, and where is the interest element here? Financial debt means, it's money given against time, for the time value of money. So how does that logic have? Actually, to be honest, I haven't seen the Supreme Court judgment in detail on the home buyers issue, but I'm not sure if they've touched upon the time value of money concept for home buyers. Because that's like a key piece, right? Financial debt has to be for time value of money. Okay, so now the guy who gets appointed first is only an interim resolution professional. Of course, his appointment has to be confirmed by the COC eventually, and then he's called a resolution professional. Most of the decisions can be made by 51% agreeing by value, and the critical ones require 66%, which obviously includes the resolution plan itself. And here again, originally the threshold was 75%. It was reduced by an amendment. And one interesting political economy point here is that most of our creditors are public sector banks, and in practice it was found that there was a lot of deadlock because there is some sort of an ideological divide between the private sector banks, the public sector banks, and the foreign banks. So it's like cut into three sides, so to speak. So therefore, hitting that 75% number was proving to be significantly difficult. As a result of which, the government decided to reduce the threshold to 66%. And I understand that this has actually helped in more effective decision making as far as the resolution plan is concerned. Now the COC, once it's set up and when in operation, it has a lot of flexibility to decide what on whether a company is viable and whether it should be rescued. A recent amendment gives them the flexibility to actually send the company for liquidation on day one. There was some doubt on this in the beginning as to whether COC should necessarily invite plans first and then decide whether the company should be sent for liquidation or not. But now that's settled. There is a new amendment which says that they can do this at any point. So basically, the ball is in their court. If they think that there is no value in this company, they can send it for liquidation on day one. And again, this entire reliance on COC, if you look at to the thought process in the BLRC, the schemes of arrangement for mergers in India, that's one piece. Although it's like court-driven, it works really well, and that's largely because the court has a very limited role. Parties come together, they decide, they give a scheme to the court, and the court, it intervenes only in limited circumstances. So that was the design logic. That's where they got that principle from, and kind of brought it into IBC, where the role of the court is limited to very few items like compliance with applicable law, so on and so forth. But broadly, you trust the wisdom of the market, you trust the wisdom of the committee of creditors to decide whether to rescue, liquidate, and if you decide to rescue, how you decide to rescue. Now, so there is one slight odd issue that a lot of people don't talk about much, is that if you look at the definition of a resolution plan, it says that it means a plan to resolve the corporate debtor as a going concern. Now it's been interpreted as by the NCLAT as you have to resolve that corporate debtor as a going concern. So you can't merge it into another entity, you can't sell it as a going concern, so on and so forth. But if you look at the original objective, the idea was to let the COC decide anything as long as there is some resolution. The law has recently been amended to allow mergers, restructurings, etc. So at least there is at least clarity on one issue going forward, that you can actually do a scheme of arrangement as part of a resolution plan. However, the point on going concern sales is still not settled. Like it's in some of the other jurisdictions, one of the quickest way to resolve a bankrupt company is to basically sell the entire business as a going concern and just distribute the cash to the creditors. And this is typically done in first day orders, where you actually get the entire transaction finalized even before you file. And the moment you file, you just sell the business and you take the cash and distribute proceeds. That's unfortunately not possible because of this interpretation. where it says that you have to resolve the entity as a going concern. So that entity has to be going concern. Whereas in sales, what happens is what is left is basically a shell company with cash, because you sell the business to a third party. So unfortunately, they have taken a very mechanical approach to interpreting this, as a result of which these kind of sales are not possible. I hope this gets sorted very soon. Then, the resolution plan must satisfy certain requirements. The cost of IRP have to be paid in priority to everybody else. So therefore, that's how we incentivize a market for IPs, and it's working really well. But another research question is that there is no waterfall or order of priorities for the costs. So therefore, all the costs have to be treated similarly, whether it's IRP, interim finance, costs of running the business. So maybe one research question could be, should we have a waterfall within the waterfall to basically prefer to give preference to some of these costs? Like arguably, for certain kinds of rescue finance, like interim finance, which is secured, should that have super priority? Because currently, even that would actually be at par with the cost. Now, a new amendment that has happened post SR is that so the amendment says that if a plan complies with the, so basically every plan would say as to how would you distribute the proceeds among the creditors and other stakeholders. And the amendment says that as long as you meet the order of priorities in section 53, which is the waterfall, the plan would be deemed to be fair and equitable, right? So this kind of removes the possibility of litigation, because before this, the COC had full flexibility to decide whatever they wanted to. And CLAT, there was this ruling which said that you have to treat them fairly, as a result of which in some cases the COC treated them fairly, and and in some cases they didn't. There was a lot of litigation on this issue. But going forward now, it's very clear that as long as the plan meets the requirements of 53, it will be deemed to be fair and equitable. Operational creditors, this is the safeguard that we give them for not participating in the COC. So they have to get at least the amount that would be due to them if the money were to be distributed in the order of priorities in section 53, or the liquidation value, whichever is higher. And just to kind of break it down, basically, sorry, someone asked a question? No. So the liquidation value would be, you sell all the assets of the, you assume that if all the assets of the company were to be sold today, not on a going concern basis, but at their market value as is, then this is the amount of money you will get, and then you will distribute it among the creditors. And what would that creditor get if that money were to be distributed in that order? It's possible that for operational creditors, that amount will be zero, because liquidation value will always be lower than going concern value. Going concern value takes into account future cash flows. It assumes that you are a going concern company. So therefore, the valuation will be much higher. So if you were to take going concern value and distribute among the stakeholders, it will be much higher. So for them, the safeguard is that you do a comparison of going concern value and liquidation value and give them whatever is higher. And going concern value is typically the value that they arrive at in the resolution plan, on the basis of which the plans are submitted. So it can be a bit confusing, because 53 is the reference point for both going concern value and liquidation value. But for going concern value, you are looking at 53 only for the order of priorities. 53 is in liquid, it's a provision in the liquidation part, but you are referring to it to determine the order of priorities in resolution, right? And liquidation value is basically the money you will get in 53 if the company were to be liquidated. I hope I can chat separately on this because it's a slightly complicated issue.
Next lecture is on this. Guys, 4th September,
Okay, excellent. So, and once you distribute proceeds in accordance with 53, it's basically deemed to be fair and equitable. So it's designed to take care of that NCLAT ruling, which said that the distribution, the proceeds of distribution in a plan should be fair to all the creditors, and essentially meant that the rate of haircut for all the creditors has to be the same. But even if so it doesn't matter whether you are secured or unsecured. So therefore, this kind of corrects that, and it says that there are some pre-bankruptcy rights that people had, and those pre-bankruptcy rights have to be honored even in bankruptcy. And if they are honored, then the plan will be considered to be fair and equitable. Okay, so
One question here.
Yeah.
Could you maybe touch upon the implementation and supervision of the plan?
Yeah. So, in the original version of the bill, there was no provision on implementation and supervision. In the JPC, this provision got added because they felt that you in the Indian context you also require somebody to supervise the plan. Just not that you make a plan and forget about it. So most plans now typically provide for a section on implementation, where typically in some cases the IP continues to supervise. In some cases it's basically some kind of a reporting requirement where they would let let the NCLT know that the implementation is completed. And there is this section 11 which says that which puts a limitation on coming back into the IRP. A lot of people don't know about this, that once a plan has been approved, you have 1 year within which you have to try to implement the plan, and if you can't, then you become eligible to come back into the system again, because there is a bar on kind of people who can't come back into the system. And so it's not that once a plan is made and it's a done deal and there is no possibility of coming back. You can actually come back after a point. So the objective is that we do realize that some plans will fail, as a result of which you may have to come back and look at this again. So that's one related point. Second related point is that if there are plan conditions which are not satisfied, then it's also a ground for liquidation. So if you have agreed to a plan and you made some commitments and you're not honoring those commitments, then then you can make a petition to the NCLT and get the company liquidated. So this is basically meant to ensure that, to the extent possible, you try to implement the plan. And So that's the second point in relation to implementation. And lastly, there is also a criminal penalty. I don't know if you guys have been tracking the Liberty House case. You should look up for it. Liberty House was a successful resolution applicant in one of the IBC cases. It realized after the plan got confirmed that there were some issues with the company which it could not discover right at the outset, as a result of which it got cold feet and it was like, I don't want to be part of this. And they said that we are not going to implement this plan. And eventually prosecution was initiated against them because non-compliance with plan condition is also an offense under the IBC. But this is a bit of a problem because IBC gives you a very limited time to do due diligence and submit your bids and take a call on whether the company is appropriately valued. And if you compare that time frame with the regular time frame you have if you were to do this deal outside the IBC, it's significantly small, right? So you have this limited window during which you have to understand the company, make a bid, sign on, and implement the plan. And at the same time, if you were to find out that there is some huge liability you missed out, then you can be prosecuted. So it's a bit of a challenge. So how do we get around that? So that's why this is one area that should be closely examined. And even if you look at these numbers that some of these economic surveys, etc., keep throwing, saying that our rate of recoveries have improved significantly, 43% for financial creditors, around the same range for operational creditors. These are actually numbers based on agreements, new commitments under the plans. these are not monies in the pocket. So basically, what you're basically just saying that you have just kind of restructured your obligations and said that now this is what is due to me, and this you will give this to me at this point of time. But these plans still need to be implemented. You still need to get that money. So this thing needs to be tracked very carefully. And when you talk about this recovery rates that you hear about, they are not implemented numbers. They are again just restructured. They're like new agreements based on new agreements. So you have to keep you should track this very carefully. So therefore, that's. I hope I didn't go to a very different tangent, but so broadly that's implementation. But on actual practice, I think you should ask one of these practitioners as to in practice how do they kind of monitor plans. I just know conceptually that they basically set up a reporting mechanism where in some cases the IP is involved, in some cases he's not involved, and the COC continues to monitor.
We're just trying to enforce it like contracts right now because there's no other way.
No, but
From plan perspective, so part by part, the resolution plan I assisted on recently, it's just part by part implementation, like you do of an arbitral award or something, because we don't know how else to go about the enforcement mechanism.
But the fact of the matter is that you're not supposed to get it enforced separately. This is supposed to be the last.
But we
Exactly.
don't know, like, who do you show cause or who do you say make payment? How are you doing the follow-up?
But I think people should use that criminal prosecution provision
Yeah.
because that's something which will really get these guys to act, especially some of these foreign investors. Because I realize that in Liberty House they're now implementing the plan. So but it doesn't make sense to have a plan and then have litigation to enforce the plan. So that's broadly the CIRP process. Now, can we just take like a break for like 10 minutes and then we start with liquidation after this? Okay.